16th, 25 meeting of the Interim Joint Committee on Judiciary to order. If you please could call the roll.
Senator Carroll, Senator Deneen, Senator Neal, Senator Nemes,
Present.
Senator Reed, Senator Stivers, Senator Thomas, Senator Wheeler, Representative Banta,
Present.
Representative Bauman, Representative Blanton,
Present.
Representative Burke,
Here.
Representative Decker,
Present.
Representative Dietz, Representative Flannery,
Here.
Representative Griffey, Representative Kulkarni,
Present.
Representative Chris Lewis, Representative Derek Lewis, Representative Maddox, Representative Marzian, Representative Moser, Representative Nemes,
Here.
Representative Petrie,
Here.
Representative Roberts,
Here.
Representative Stevenson, Representative Whitaker, Representative Williams, Representative Wilson, Co-Chair Storm,
Here.
Co-Chair Elliott.
I'm here.
Thank you. At this time, I would ask someone to, the minutes from the September 18th meeting are in your packet, members. If at this time I would entertain a motion to approve those minutes. We have a motion and a second. All in favor say aye.
Aye.
Anyone opposed? Those minutes are approved. At this time, does anyone have any special guests they'd like to introduce? Seeing none, if we could have our first presenters on the agenda come up to the table, Representative Witten and any of your guests with you, and we're going to be on the first agenda item, 25 regular session House Bill 534, an act relating to actions for forcible entry and detainer. If you could just introduce yourselves and you have the floor.
Thank you, Chairman. I'm Susan Tyler Witten, State Representative for District 31.
And my name is George Eklund. I'm the Director of Education and Advocacy for the Coalition of the Homeless in Louisville, Kentucky.
Thank you. Chairman Storm and Chairman Elliott, committee members, I just want to thank you all for the opportunity to speak to you all about this bill today. As the Housing Task Force co-chair, the past 2 years, we've worked really hard to try to identify state-level solutions to Kentucky's housing crisis. And while most of the solutions that we've identified address the housing on the supply side, there are other solutions that we have identified that can help eliminate unnecessary roadblocks for Kentuckians to have access to housing, especially affordable housing. One such bill is the bill that we're talking to you about today, and that is House Bill 534 from the 2025 session. This bill, which requires the automatic sealing of dismissed eviction filings and protects youth from public disclosure, has been literally years in the making, with countless hours of consultation from the likes of the Apartment Association, AOC, judges, clerks, service providers, and other advocates and experts on the issue of housing. This is not a unique solution for the housing crisis. 21 other states, in fact, have already passed similar legislation. Those include Indiana, Utah, North Dakota, Nevada, Idaho, and Texas. And just last year, Ohio passed the youth provision of this bill. This bill is important as it increases the ability for working Kentuckians to have access to safe, affordable housing while explicitly maintains the property rights of the landlord. This bill makes no change to the eviction, collection, or damage claims property owners may have. It also enhances access in rental markets by ensuring the records used are actually accurate.
So in Kentucky, the main driver of eviction is our lack of housing. Like, some of our counties have the fastest growing rents in the country, and there is no conspiracy on either side of the issue between a landlord or a home renter. of nobody's trying to get out of paying rent. Nobody's trying to be malicious about filing an eviction. 99% of the time, this is just a function of the market where somebody loses wages and they can't afford rent. Sometimes a landlord needs to get paid and needs to sell a property. There are 3 scenarios that lead somebody to get an eviction filed against them. The first is a non-renewal of a lease. So this is something where nobody does anything wrong. It is simply that a landlord has decided to sell the property and they need to move the home renter out of the property. And because of our tight rental market, they can't find a place to move to. And so the landlord is left with only an option, and that is to file an eviction. Most of the drivers are people's inability to pay. And 6 out of 10 low-income Kentuckians are already spending more than 50% of their wages on rent. And so one small financial disaster, like you drop a transmission out of your car, you miss a paycheck because you have to be home be at home with a sick kid, like that can set you back months on trying to keep up with rents. The other is a lease violation. I think the most common lease violations that we see is a sibling, a sister, a brother, a mother has to move in because they also can't find adequate housing. The bright spot is 60% of the time, based on a research with AOC data, is that these cases are dismissed. And that shows me that home renters are taking proactive actions to try and rectify the situation by either moving out within time or by paying any past due rent. One thing I really want to drive home about Kentucky law and eviction is that an eviction, a forcible detainer action, is solely about the possession of the property. It is not about the collection of the debt. There is a very well established process that a landlord uses this to get possession of their property back. They give adequate notice to a home renter. They then file the forcible detainer action, and then there's a court hearing where a judge hears both sides of the issue. And if the home renter moves out within that allotted time, if they pay up that past debt, that case is dismissed. If the home renter doesn't show up, if they don't move out in time, then that is when that case keeps on moving forward. This bill would not impede a landlord's ability to send any kind of past debt to collections. It would not prevent them from filing a small claims action. It would not prevent them from keeping security deposits or other avenues of recourse that are available to them. This is really just about that forcible detainer action that is filed. We are super concerned, and we want to be very aware of the burden that this would put on the courts. Luckily for us is that the majority of counties, the vast majority, 110 counties, would have less than 16 cases that they would have to expunge each month. There are 10 counties right there that you can see that have more than 16 a month. And so some might have 20 a month. Your largest loads are going to be Jefferson and Fayette. And luckily, those are offices that have the most robust staffing. But we are very concerned, and we've heard the concerns from the clerk's office to make sure that this is an easy process for them. Luckily for us also is that you all have created an automatic expungement process for dismissed criminal actions. So this is hopefully something that we could emulate as we put this into action.
Yeah, and I just want to, I just want to again note that it is important that landlords maintain their rights for this. It's very important to me to make sure that this was addressed, and that this bill in no way takes away any avenues of recourse for the landlord. Landlords can continue to screen tenants based on legal criteria like proof of income or credit scores. They can still file evictions. They can still collect unpaid rent, and they can still pursue other legal claims or seek charges for property damage. This bill simply removes a barrier for tenants with dismissed eviction cases that would otherwise be a hindrance into finding available and affordable housing.
So a lot of my work, I feel like I'm walking in two worlds. I feel a lot of times like I'm on the balcony where I'm just looking down and seeing kind of how all these systems that we're talking about are interacting together. I also find myself in a world where I'm on the dance floor with people that are working on case management. They're doing housing navigation. And one anecdote that I just want to share is that, there's a family up in Northern Kentucky right now that is staying and paying rent in an extended stay motel. And these are folks that are working, but because of a past eviction on their record, they cannot find that stable, more permanent housing setting. So they're left renting month to month or week to week in an extended stay, where it's not a sustainable place. It's not a thriving place that a family wants to be. It is really just a temporary space while they're trying to figure out what's next for them. We do lack over 200,000 units of housing, both on the homeownership side and on the rental side. Eviction impacts families every day. In Jefferson County, we have about 17,000 evictions that are filed each year. And even regardless of the situation, these records go on people's records permanently. So even if it's a mistake, even if it is an issue that gets rectified really quickly, there's no way that any kind of landlord screening software that is marketed to the industry can kind of really delve into the nuances of each individual case. So, and ultimately, I want to create a space where we are promoting stability and success for families and not holding people back from their potential.
Yeah, and just to wrap it up, just in conclusion, this bill, it really just provides a simple solution to a hurdle that many Kentuckians face in their attempt to find secure housing. It ensures landlords receive accurate, current information. It removes barriers for tenants with dismissed cases, and it complements our broader efforts to increase Kentucky's housing supply and affordability. So I appreciate the time, and we'd be welcome to answer any questions that you all have.
Representative, a copy of your legislation is actually in the members' packet, correct?
Yes.
Thank you. At this time, Senator Wheeler has a question.
Thank you, Chairman Storm. And, I can see the usefulness of this legislation for some folks that find themselves in a bad way. But I do have some concerns, and I'm not saying that I am fundamentally opposed to what you're trying to do here, but sometimes I've seen where people will just like in any type of civil action, sometimes there's a settlement. Okay, for example, I've noticed some courts tend to, especially if they're, the whole part about not having minors in there, I can totally agree with that. But sometimes courts will delay the eviction if there's an extenuating circumstance, or you'll even have, legal aid pop up and start throwing a lot of hurdles in that might delay an eviction for multiple months. And sometimes, they'll agree, the property owner, just to get control of the premises back, will agree to dismiss the eviction if they're out in 5 days or, some limited amount of time. I kind of think on some level a subsequent landlord might deserve to know that. I guess I'd like to know what your response to that would be.
Yeah, I appreciate the question, Senator Wheeler. For me, I was thinking yesterday, I'm thankful we have an eviction process. I am thankful that it is a supervised process by the court, because what would a world look like if we didn't have an eviction? We would have landlords forced to take actions, home renters forced to take actions that would not be appropriate. For me, I think that if we were talking about a contract issue, and if the case is dismissed, that was an agreement that was entered. If a landlord has issues, they can keep on pushing, and they have other avenues to appeal it, they can keep it going. And in my experience, what I'm seeing is that the people that are getting these cases dismissed, they're the folks that are taking ownership over their issue. They're saying, hey, this is my fault for whatever reason. I'm going to take proactive steps to do it. Those that are getting judgments, that is where you have the people that are not being accountable. Those are the ones that are not paying up their rent, or they're staying too long. So I think this is a very narrow scope of what we're trying to do, just to start trying to create more opportunities for people on getting into housing.
Like I said, the premise of the bill,
Yeah.
I'm
Yeah.
not fundamentally opposed to, but I can think of a couple cases through the years in my practice as an attorney where, like I said, there's some really sharp people that go to legal aid, and they sometimes know the eviction process better than I do, or a lot of other attorneys. That's something they deal with every day, and they are remarkably successful in keeping people in those homes for a much longer period than maybe what they should be.
Yeah.
And they can't do that without the cooperation of the tenant, and I'm not sure if you're essentially forcing somebody's hand, if that's really fair.
Yeah. And I would love to hear more about those cases specifically, and we are open to hearing and brainstorming ideas that we can kind of make sure that this is the best product that we're putting out there.
Right. Yeah. If there are loopholes that will enable bad actors, we certainly want to close those loopholes.
All right. Thank you.
Senator Nemus.
Yes, thank you, Chair. Thank you for bringing this, because if we keep people in housing, it costs us less to have affordable, low-income housing that we're subsidizing. But as a landlord, I still have some reservations, like Senator Wheeler. But I think that the way you wrote the bill and what you're coming at kind of calms my fears as a landlord, because a lot of times I would file an eviction in front of things. I just wanted them out of there, and I'm very happy. So if it's dismissed, that's fine. I can re-rent it and that. So the main thing that you said that calms my fear is if I still go after them for the money owed or the damages, that is still on their record. It's just the dismissed case is not. So if they come up and pay in that and we dismiss that, that's my decision to get it off the record on that. So a future landlord, which Senator Wheeler was stated, is what my fear was. I want to know, as a future landlord, if Susan Witten got kicked out because she wouldn't pay, I want to know that, so I won't rent it to her. But if she did pay and there's no other action, just that she fell into hard times and whatever, and I filed a suit to get her out and she got out, then I'm fine with that being dismissed. The question is that correct, what I'm stating?
Yes.
Yes, that is correct. And generally, when I've spoken with landlords, there are 3 avenues that they'll take. They will either file a small claims action, they will send it off to collections, or they just accept that they're not going to get that money back, and they'll write it off in their taxes as a loss.
Representative Dietz.
Thank you, Mr. Chairman. Representative Witten and I have talked about this bill. I was primary co-sponsor last year. I'll be primary co-sponsor this year. I can tell you, in my domestic practice at home in northern Kentucky, I represent a lot of parents that find themselves single, and a lot of times they're one child support payment, one spousal support payment away from missing their rent, and then it's just a snowball effect. And I think this will help some of those single parents, so they're not living in a hotel paying a weekly amount when they could be getting a rental and putting their family in a home, which is something we all advocate for, is for the family. So I'm happy to be primary co-sponsor of this bill again.
Thank you.
Representative Cole Carney.
Thank you, and I'll be brief. I know that there's a lot of work that has been put into this piece of legislation and all of the conversations that you all have had, and just want to draw attention to the fact, and Senator Nemus's comments kind of clarified that how very narrowly tailored this bill is. It is only applicable to dismissed cases. It is only applicable for when there's no other issue at hand. It does not curtail landlords' options. in terms of seeking relief or getting money back, or in fact any aspect of a landlord's options. So I want to thank you all for bringing this bill. It's a real barrier. It's a very real, tangible barrier for people who are trying to find housing at a time when we're trying to fix that issue. And this is just, to my mind, very low-hanging fruit, and it would help a lot of families avoid being homeless. So thank you very much.
Thank you.
Senator Thomas.
Thank you, Mr. Chair. And full disclosure, like my colleague Senator Nemes, I'm a landlord. You know, I rent to individuals in Lexington. However, as I've looked through your bill, Representative Whitten, and it only applies to dismissed forcible detainer actions. Am I reading that correctly?
That is correct.
Well, we already have a policy in our state that allows for expungement of guilty misdemeanor and felony charges. I mean, these are people who've been found guilty. That's right. And we've already said as a state policy that for those certain offenses, after a certain period of time, we're going to eliminate those from your record after you've been found guilty as charged. Here in your bill, you're only talking about dismissed cases, not cases that have been filed, just those that have been dismissed, where the court, for some reason, one reason or other, has decided that this case has no merit and it should be dismissed. Okay, I fully agree with you. I don't see any reason why a civil charge that's been dismissed against the defendant should stay on that defendant's record and prevent that defendant from getting an important requirement in our society, such as housing. I mean, we think about food, housing, clothing as being the three essentials, maybe healthcare being the four essentials of just living, and to deny someone that right when that action's been dismissed against them, just seems totally wrong, maybe even immoral to me. That would stay on that record and deny them from getting housing. So, I mean, consistent with our policy that we already have, where we dismissed fully charged and guilty criminal actions, this is an obvious next step to me to say we should expunge dismissed forcible detainer actions. So I support your legislation.
Thank you, Senator.
Representative, I'm sorry. Yeah, I have a question. Does a dismissal require a judge's order?
Senator, my understanding is yes, it does require the judge to sign off on a dismissal.
So this isn't just the parties. This is something that a judge actually enters a written order that says dismissed, correct? And then focus on line 17 for the committee regarding the juveniles sometimes appearing in these petitions. Explain that anomaly that sometimes occurs, not all the time, but occasionally does.
Yeah, this comes up probably once a week in Jefferson County Court, or the eviction court docket. I don't think that there's any malintent on this. It is just an attorney is given a stack of cases from the landlord, and just to get it off their desk, I think they're just filing on all occupants. I think what we would like to see is them just to focus on who is the leaseholder, not just all occupants. And I think there are a lot of administrative ways that we can help eliminate this from happening. It is just a mistake that happens, and a child's name gets put out there in the public record, and we just want a structured way to claw that back as quickly as possible if it does happen.
Thank you. Any further questions? Seeing no further questions, thank you for your testimony.
Thank you.
Thank you.
This time we'll go into item number 4 on the agenda, Senate Bill 111, an act relating to juvenile justice. Those presenters can come on up, please. This is Senator Carroll's bill, and members of the committee, Senator Carroll had a personal matter that occurred. He is unable to be here with us today, but the commissioner and these other presenters are very well informed about the bill, and I believe they are prepared to go forward without his being here today. And I think this is also passed out of the Senate Judiciary Committee in the past, and the actual Senate. Make sure your microphone's on and identify yourselves, and you have the floor, please.
There we go. I'm Randy White, Commissioner for the Kentucky Department of Juvenile Justice.
I'm Nancy Galvani, President of Kentucky Hospital Association.
Good morning. My name is Dr. Clark Lester. I'm a child and adolescent psychiatrist with the University of Kentucky and work as DJJ's Chief of Mental Health.
Okay, so thank you for the opportunity to present this morning. I think that we have presented this material a time or two in the past, and we're happy to appear before you again today. And we have some additional information that we'll be providing within the content. I've got a narrative to read through, but at the same time we have a PowerPoint. So this narrative will roll right along with the PowerPoint. So if you're ready, I'll get started with the talking points.
Commissioner, please pull your microphone a little closer. It's hard for me to at least hear. Thank you.
Is that better? Better? Okay, if you're ready, we'll move forward with the PowerPoint. The bill before you for consideration is one that you have seen several times in the past. Among other critical need provisions in the bill, such as 2 new additional female detention facilities, this bill requires that a facility be built specifically for high acuity mental health needs for youth in detention, allowing them to get the appropriate care they need at a secure state-run medical facility. Until that facility is built, this bill the care they need at a secure state-run medical facility. And again, until that facility is built, this bill outlines a process with incentives for private hospitals to provide inpatient treatment with adequate safeguards and increased compensation. In this way, Senate Bill 111 fills a gap in services for youth with significant mental health issues and who are violent where private options are limited and detention is not the appropriate setting for specialized secure care. Governor Beshear and the Department of Juvenile Justice continue to explore this model and how it should be implemented, but we're getting to the point where we need to take the next steps towards design and construction of the facility. One may ask, why do we need this facility in Kentucky? Whether a youth has committed murder or is a truant, DJJ must accept any youth who is court-ordered to detention. Some of these youth have severe mental illness that render them extremely violent. As with any youth who suffer an emergency medical crisis, an uncontrollably violent youth needs to be in a hospital receiving treatment. Detention centers are not equipped to treat mental illness requiring hospitalizations. That's not their purpose. Private psychiatric hospitals are not required to accept DJJ youth and routinely refuse to accept or prematurely discharge these youth because of their violent, assaultive behavior, often resulting in hospital staff injuries. Placing a severely mentally ill child in detention is not the appropriate placement for that child. These youth also require a disproportionately high number of staff time and resources to ensure their safety and security, as well as the safety and security of DJJ staff and other youth housed with them. At this time, I'll turn it over to Dr. Lester to discuss the number of youth from the last 2 months that DJJ or the courts referred for inpatient psychiatric care and how many were accepted or not accepted.
So in terms of numbers, in August of this year, we had a total of 45 youth who were referred and assessed by private psychiatric hospitals in the state. Of those 45 in August, 34 were denied. We don't always know the reason for denial, but at least 5 of those explicitly said because of aggressive behaviors. In the month of September, we had 38 referrals. 30 of those were denied. 2 of those explicitly said for aggression. And so when you look at the rate of denial for youth coming out from juvenile justice systems, for August it was 76% were denied, and in September 79% were denied.
So one may ask, how does the facility that we're proposing solve this problem for Kentucky and the Commonwealth? Investing in a high acuity mental health facility for justice-involved youth in Kentucky is very necessary to properly serve this group. A dedicated facility would provide access to behavioral and psychiatric care for Kentucky's justice-involved youth who have no other viable options. It also provides a safe and secure facility that is specifically designed and built for the task of caring for justice-involved youth who require specialized treatment. Most importantly, such a facility creates better outcomes and improves futures for youth in our care in this state. They're going to grow up to be adults. So who would this facility serve? The facility would serve youth who have been determined by a clinical professional following a behavioral assessment to need a secure treatment environment and specialized services. These youth are a safety risk to themselves and to others in detention, and they require a high level of psychiatric care, and they've been refused by placement by hospitals. Kentucky needs a high acuity medical and mental health facility for our youth. You've probably heard about the case referenced in the media and in legislative testimonies about one particular youth who would have benefited from access to this type of facility. This particular youth was ordered and detained by a judge, and DJJ had no other choice but to obey that order, even though she suffered from severe mental illness. In all fairness, the judge did not have an alternative to detention, as she was also extremely violent. That said, detention only exacerbated a deterioration in her mental health, and she was a danger to herself and incredibly violent with DJJ staff and destructive towards her property. Our department tried 9 different times to place her in a private treatment facility, both in and out of the state of Kentucky. Each time she was refused admission primarily because of her aggressive and self-harming behaviors. In one instance, she barricaded a nurse's door and physically assaulted the nurse, who experienced injuries as a result of that assault. In short, she could not access critical services for her behavioral and mental health needs because she was not an adult. When she turned 18, DJJ filed an involuntary commitment petition alleging that she was mentally ill and was therefore a danger to herself and others. Our department was fearful for her safety when she would be released from detention. Thankfully, the courts and clinicians agreed, and she was admitted to a state psychiatric hospital where she received beneficial treatment, and it was probably, in most likelihood, first time in her life. It is very unfortunate that she could not access this treatment until she became an adult. If Kentucky had a high acuity mental health facility, if it had been available to her as a youth, she and others may have been spared years of turmoil, distress, harm, and received treatment much, much earlier in her life. The spectrum of facilities and care options. As part of the statewide assessment of DJJ facilities, a critical need for treatment-focused housing was identified. While mental health programming, counseling, and some treatment services are integrated into the current detention facilities, there is a gap in facility and care options available for both youth and with severe and persistent mental illness that can only be filled by a treatment-focused facility or pediatric hospital. I think slides number 7 and 8, forgive me, they're duplicate slides, so we can move on to slide number 8. So how would this facility meet the needs of the juveniles that we're referencing? This facility would allow for certainty of placement, creates a secure environment in medical and psychiatric resources, allows for juvenile justice to adhere to clinical requirements and statutes, and would incorporate trauma-informed design within the facility plan design. To reiterate, existing juvenile detention facilities are not appropriate for youth in need of high acuity support. A dedicated facility to meet high acuity needs allows youth to be treated by a variety of mental health professionals and clinicians in a medically equipped setting that cannot be replicated in existing facilities. It also helps to keep staff and clinicians safe. Next slide will be in reference to design of the facility. The way that this facility is proposed demonstrates that security and safety measures can be balanced and complementary to clinical spaces while meeting all statutory requirements. The facility would incorporate innovative design for circulation, sightlines, and placement of central hubs for clinical services to improve efficiency, safety, and security while providing individualized care. While one or two other states have implemented similar mental health facilities for youth in detention, Kentucky is proposing a building, a structure, a physical plant that would serve as a leading national model in best practices in juvenile rehabilitation. Population of the proposed facility. The proposed facility as outlined in the bill would be for 24 total beds to accommodate the highest level of need. Again, this would be for psychiatric, clinical housing, and assessment stabilization housing. The psychiatric clinical housing would include 2 8-bed units with 16 beds total. The assessment stabilization housing would include 4 2-bed units with 8 beds total. So at this time, I'll again refer to our expert, Dr. Lester, to talk about the potential number of youth we think would be eligible for such services. It's a much larger number of youth, especially female youth, than what you would expect.
And so I think there are different ways to look at this number of exactly how we would use this. If we look at the numbers from August and September, August, 11 youth were identified and met criteria for inpatient hospitalization in private hospitals. Private hospitals often are also overburdened with lack of bed space, and so we run into a similar issue where they've recommended inpatient treatment, they don't have beds available, and so I think that's one place where we can look at those numbers. But if you look at the number of denials too, we're talking about 34 youth in the month of August and 30 in the month of September. Among the female population, 14 were denied out of the 16 that were referred for inpatient hospitalization. That's an 88% denial rate. That's not to suggest they did not need treatment, but when we look at these numbers, a 24-bed facility would stay full and likely have a waiting list.
So at this time, I'll transition in the presentation to the 2 new female detention centers. This bill also includes a critical need for 2 new female detention centers. So this facility, the number of females in detention has steadily increased since 2024. There's a need for 2 new detention centers for females specifically to meet the requirements to move toward a new regional detention model as outlined in 2023 regular session Senate Bill 162, while maintaining the separation between high and low level offenders and male and female youth, which is very important in the safe and secure management of our juveniles within detention. So a question is, why 2 female facilities? Housing females in each region would require significant construction projects at all 8 existing juvenile detention centers to maintain separation requirements per 2023 Senate Bill 162. So we're talking about extensive renovations in our existing detention facilities, which would disrupt operations of those facilities. DJJ is currently working on facility projects in Fayette, the Linden neighborhood or the Linden facility in Jefferson County, McCracken County, and Breathitt County, and all those are male facilities. Female youth are currently housed at Boyd Detention Center, but that facility is needed to house male youth in eastern Kentucky in that region in order for DJJ to return to an 8-region model for male youth. Further, the currently funded youth detention center retrofit project scopes do not include additional capacity required for combined male-female facilities. Female JDC concept design. Facility design must include spaces for intake, administration, visitation, medical, housing, among other needs. The preliminary design for each facility would allow for 28 beds across 4 housing units, and that's in each of the 2 facilities. Programming discussions centered around these facilities have indicated that there are unique challenges for young females involved in the justice system, including a high prevalence of self-harming behaviors and past traumatic experiences. The proposed facilities would incorporate trauma-informed design principles to create space that allows for both physical and emotional safety for female youth. In closing, we know that a high acuity mental health facility can balance and complement security measures and clinical support spaces while meeting statutory requirements. This is why Governor Beshear proposed such a facility in 2024 regular session. And the Capital Planning Advisory Board, comprised of members of all 3 branches of government, recently recommended funding these facilities. We are hopeful that this legislation and the request to fund these facilities will pass both chambers and become law. Senator Danny Carroll and Senator Storm has been involved as well, have worked closely with the Justice and Public Safety Cabinet and the Cabinet for Health and Family Services for over 2 years to address the gap in facility and care options available to these specific youth in DJJ custody, and that is reflected in 2025 Senate Bill 111. DJJ advocates for a high acuity mental health facility as proposed in the capital plan and budget request. Based on preliminary estimates, DJJ would need $35 million to support design and construction of the facility. I think that's the end of our presentation. It's probably likely there are questions, and we'll try to answer those questions. Did you have any additional information?
Did you want to add anything now or wait till questions?
I have some remarks, just very briefly.
Okay.
Thank you. So good morning, Chairman Storm, Chairman Elliott, members of the committee. Thank you so much for allowing me to be here today to talk about the problem of violent youth in our hospitals. And this is an extremely important bill. We've worked with Senator Carroll for the past 2 years, setting out a process that's really in the beginning part of the bill to address this. And so we are very strongly in support of its passage. There's an increasing number of high acuity youth being treated in our hospitals. Our hospitals are admitting these patients. Just to give you an idea, in December of 2023, Kentucky's freestanding psychiatric hospitals reported to KHA that at that time they had 129 high acuity youth being treated in their facilities. We surveyed them again recently. That number has jumped to more than 500 patients in August of this year. The majority of the high acuity youth have severe aggression along with homicidal ideation, followed by suicidal ideation and self-harm. Kentucky's hospitals are asked to admit these youth, even though they have highly specialized clinical needs that require a different and more intensive level of resources, staffing, and physically secure facilities than is typical for inpatient psychiatric care. For example, aggressive youth often require 1-to-1, that's like 1 patient to 1 staff, or 2-to-1, 2 staff to 1 patient, or even 3-to-1, 3 staff to 1 patient to keep a safe environment. But these staffing levels then strain the ability of the hospital to serve other patients, and it limits the ability of the hospital to admit other patients. It's not uncommon for a high acuity youth to be housed, a single high acuity youth to be housed on an entire wing of the hospital by themselves due to their aggression. High acuity youth create costly property damage, but more importantly, as you've heard, cause injury, sometimes to other patients, but certainly to the staff of the hospital. There's been multiple instances of high acuity patients beating up staff and instigating riots. In one instance, where the hospital was asked to admit several high acuity youth, these youth then instigated and participated in a riot against the staff. The local police were called, but were unwilling to do anything. In other words, it was the hospital's problem to deal with. The staff were punched, several had broken bones, and others that were witnessing the incident quit on the spot. The hospital struggled to even be able to separate the perpetrators by transferring them out to other hospitals to calm the situation. Another example of the dangerous nature of these youth revolves around a patient attacking a staff with a brick and causing multiple injuries, including a brain injury. I could go on and on. There's too many of these incidents to describe them all, but you get the point. Clearly, clinicians need to be able to determine the appropriate setting for the patient's treatment for the safety of the patient, the therapist, and the other patients in the facility. So our psychiatric hospitals urgently need the process that is included in Senator Carroll's bill, and it's going to allow the hospital to do a clinical evaluation of a high acuity youth before being admitted to determine if admission is appropriate. And also, of course, involving the Department of Juvenile Justice, Department of DCBS in that determination, as well as setting out a process to discharge a high acuity youth for committing an act of violence after they're hospitalized. Hospitals need to have a safe environment to provide care, and this bill is going to help us achieve that. Thank you.
Senator Wheeler.
Thank you, Mr. Chair. I guess if you indulge me with a couple of brief questions. One, I mean, my understanding is not what Eastern State and what's the one in Louisville, is it Central State, that are they not the two, I guess, high acuity mental health hospitals that are kind of state hospitals? Is my understanding of that correct?
So those Central State, Western State, Eastern State are all state psychiatric hospitals that are considered 202A hospitals, but they serve adults only. They do not serve adolescents. So if you're under 18, you cannot be admitted to those facilities. Is that
by statute, or what's the basis?
I'm not a lawyer, but I believe so.
Okay. I mean, I don't know. I mean, you know, maybe adding something on to those facilities where you may have concentrated professionals and care, you know, rather than just constructing a whole new facility. Maybe you would get, you know, triple the impact there, and then have an easy method of transitioning them into adult care be one possibility.
Senator, I think one of the overriding concerns is these are juvenile offenders, and we would want to keep them separated from the adults. And I know physical plant and things aside, but the juveniles that we're talking about are justice involved, they're court involved. They've committed offenses for the most part, and there could be some concerns on the hospital, again, with accepting court involved or justice involved juveniles into a facility like that. So again, we're not attorneys, but I think those are the most immediate concerns.
That may bring up a broader question. Do we have an asylum or something like that in Kentucky right now, even for adults, where we put these type of people in long term, or is it merely 202A facilities? I mean, I guess that's the question. I mean, where do you put people like this long term that maybe just aren't going to get better but are, you know, prone to violence?
That's a complicated question, I think. In terms of just language, we don't use asylum anymore, but a lot of the places like Central State, Eastern State have longtime residents that have been there for years, and I can speak to that as I used to be an attending at Eastern State. And so there are those individuals, but I think that goes beyond what this discussion is.
Sounds like a non-answer, but okay.
Representative Banta.
Yes, thank you for your presentation. I just want to say I think the numbers that you're throwing out, or not throwing out, that you're giving us, 24 beds doesn't even sound like it scratches the surface. I don't know why, if you were going to build something, why you wouldn't build it so they could come. But so I guess my question is, you landed on 24 beds. How would we even staff it? Because all I hear every time we come in here is that the turnover rate, people won't do it. People at the hospital walk out when they see it. So even if we built a state-of-the-art facility, how are you going to get people to work in it when they're getting beat up and their hair pulled and beaten with bricks every day?
I don't have a magic answer to that, but we have had those internal discussions about how we could best staff a facility. We think through specializing in mental health care, we would be able to recruit those from local colleges and the local areas that would want to work in a focus facility that would focus on mental health treatment for these juveniles. We think that we would be able to recruit at colleges, recruit those young professionals or aspiring professionals that would want to work in such a facility that's going to see a benefit through treatment, a treatment-oriented approach. So we would try to locate such a facility near a major metropolitan area. Of course, we would want to do that for a couple of reasons. To make the physical location would be close to services and to the professionals required to offer those services, but also near a region where we would have a robust community to attract staffing from.
Representative Burke.
Thank you, Chair, and thank you, panelists, for this presentation. I want to start by just simply expressing that I am wholeheartedly in support of this, but I'm first going to echo Representative Banta's noticing that the proposal is for 24 beds when we're hearing that the need is much greater. So I'd like to dig a little bit deeper on that. If you could, can you tell me on average how long a stay for justice-involved children with severe and persistent mental illness would be in a facility like the one that's proposed?
And I'll go back just one step to address Representative Banta's question, is that what we do experience and what we do see in other facilities is that the violence and the staff are not primarily trained in general to deal or to manage or to know what to expect from the youth that we're referring to. And that's been a detractor for staffing. It's been a cause of turnover because the staff are frustrated. They have not been properly trained to manage and to interact with the juveniles we're talking about. And so what we're proposing in such a facility is to attract the aptitudes, the type of staff members that we want working in such a facility with a clinical, a therapeutic mindset, but we also want to work with other state agencies to bring those staff in at a higher level of training, both for the staff wellness and for the therapeutic treatment of the juveniles that we're referring to. So again, the average stay, I can talk to my colleague, Dr. Lester, and try to get an accurate answer for you for the average length of stay.
And I can't give you an exact number, but in terms of, we're talking about when we imagine this type of facility, that we would have a collaborative treatment team that both evaluates who needs this level of care and then how long that care is needed. And so it's really going to be dependent on the individual's needs and the diagnosis. So if we're talking about some acute episode, 5 to 7 days maybe. Mm-hmm. But for a lot of the youth that we're talking about with chronic complex needs, we're talking a much longer time period on the range of weeks to months.
Thank you for the answer. Having grown up in a family with an aunt who has violent outbursts from schizophrenia, I've watched this for 40 years, and so I know what this looks like in practice. I've seen it also as an attorney working with families when children are out of control, become justice involved, and it's because they have such severe mental illness that even community supports and all the right people sometimes can't help, and things like this are needed. What percentage of detained youth with severe persistent mental illness may not be suitable or safe for transfer ever back to a DJJ facility? Are could we fill 24 beds with young people who aren't ever going to be suitable to go back to a DJJ detention center?
I can't give you any specific numbers on that, but I cannot imagine that we would fill up the 24 beds with kids who could not then return.
Okay.
And I'll leave it there.
Okay. And one final question. Will referrals to private hospitals continue after this new facility is created so that we don't experience a huge backlog from failing to continue the referrals?
Yes, as I mentioned, our hospitals are taking these youth, but there are some youth that, we need to be able to say we can't meet their needs, or they're not willing, they're not ready for treatment. You do have to be ready for treatment, but certainly we're not suggesting that the hospitals would not continue, but to have a process on the front end so that those evaluations can occur and the patient gets to the right place is important.
I'll also add, a lot of the youth that we're talking about are pre-adjudicated youth, and so we are housing them for the court. The families and the youth themselves also should have some degree of say, I think, in where they receive treatment. A lot of these families have preference, and so I think that option should still be on the table. Some of them are going to be appropriate, some are not, based on their behavior, and also considering the hospitals have to consider what patients are already there and how that their milieu is the word we use, how that's going to be affected by bringing in this other potentially volatile, aggressive youth. So,
and I think, Representative, going back to one question about the 24 bed count, it would be prudent, and I've been involved in correctional facility design on a large scale in my previous career with corrections, but it is very prudent to anticipate either surges or changes in the trends in society, the treatment needs, population growth. And what we found is that it's very prudent when one designs and builds a facility to design it for expansion. We've done that in some of our correctional facilities, most recently the Little Sandy Correctional Complex. So it was already designed to build out and add to that population. So you try to go ahead and catch it on the front end. So we're not the only states that have endeavored with these types of initiatives. Most recently, we've been in collaboration with South Carolina, and they are moving forward with a very similar process, and their design is a co-ed facility with 24 beds in it.
Thank you all for your time, your presentation, and your responses.
Representative Mosier.
Thank you, Mr. Chairman, and thank you very much for this important discussion. I have long known that this is a problem. We have high acuity youth with absolutely nowhere to go, and all of the problems that you've described. I have a couple of questions about who establishes the eligibility or the criteria for the individual child. Is this a medical transfer agreement, or is this the Department of Corrections petitioning the court? And who makes the decision about where the child is housed? Because I don't want this to be used for a kid who has some psychiatric issues, but they're not the high acuity youth. I don't want this to just become a place to stick kids that are hard to deal with.
Yeah, and the simple answer is we're not interested in warehousing, we're interested in treatment. So we would want to stabilize and get to a point that we provided effective treatment, and then hopefully we could move that juvenile offender back to a different environment just for the sake of bed space. We work closely with our clinical providers, and I think Dr. Lester can explain maybe just a surface explanation for the process. But it would be clinically driven. The gatekeepers, of course, would be juvenile justice, but the people that would get them there are going to be our clinicians, our psychiatric providers.
And I would echo that, in that I think internally we would need to determine who needs this level of care to triage the needs of the youth. So but those are details that I'm not been a part of those discussions so far.
Right, and I know that there's a lot of variability in the patient population, and I'm just curious, if these are all pre-adjudicated youth, the court may or may not be involved, or does this touch on our? Yeah, I mean, I guess this would be determined as to whether or not the child had participated in a violent crime. But I mean, does this touch on our 202C statute?
Representative Moser, the front part of the bill that we are most concerned about sets out a process, and it's DJJ involved youth, but it's DCBS as well. And again, sometimes they're brought to the hospital, but we need to be able to have that clinical evaluation. The bill spells out who's defined as a high acuity youth, and also, you have to be the correct person. It's going to be the psychiatrist at the hospital that's going to do that evaluation. And again, we have 500 of these kids in our hospitals today, so we're not saying we're not going to take kids, but there could be some that we feel are just, they're coming into our hospitals saying they're going to beat up our staff, that we have to say we don't think this is the right environment at this time. And again, we write that up, and that goes to DCBS and DJJ, and they weigh in on that. And so we're going to come to agreement on what is the appropriate treatment plan and what's the appropriate placement.
Okay. All right. Thank you.
Representative Nemus.
Thank you, Mr. Chairman. Wanted to note that in my mind, we're conflating a lot of things here. We're not everybody that's justice involved as juveniles who have mental health issues are obviously anywhere near the same. We're talking about angry kids all the way to kids who will never recover, like the lady that the commissioner was speaking about that was in Adair and also in Warren County with some significant issues with her life. But she'll likely, hopefully I'm wrong, but she'll never be most likely able to make it on her own in the world. So she's a very different category than a kid who's going through a moment and who's very angry, and hopefully we can get them treatment and they can be on their feet and be great citizens. And so I don't think I'm for this. I can be talked into it, but I don't think I'm for this because I think it's much too small. Yes, we need to address those who are in a moment that we can treat and get better, but we also, I don't see the other population, which is what the 24 beds are designed for. I don't see that as a population where we should split out the juvenile from the adult. And don't freak out on me yet. But the reason is because that juvenile, when they become, what are we going to do? We're going to release them from the facility to where? We don't need a solution for them until they become 18. We need a solution for them their entire lives, many of them. And what we've done in the 60s and 70s is the pendulum was too far on these mental health institutions, and now the pendulum is way too far on the other side. Central State, just as Senator Wheeler was discussing, Central State just closed the wing, so we have some space. Not ideal, okay, fine. But I don't think the solution should be a solution for 18 and under for that population. I'm not talking about the broader population that the hospitals are serving, the 500 kids. I'm talking about the 24 kids in that population, whatever number it is. We need a longer-term solution, and just building a facility that helps until they're 18 is not getting the job done. In my community, and I know communities all across the Commonwealth, but I know Louisville personally, we have several people who commit crimes or just mayhem or whatever they continuously, and they get released, whether it's a 202A, it's not 202C, that's separate, a little bit separate, but the 202A process, it doesn't work because they get in there for far too short of a time, and they get right back out and they go to the same location and cause the same problems. It's not helping that person because they need to be in an institution. And so what I'm saying is this: I'm not for this because this is far too small of a resolution. I can be talked into it if I'm wrong, but we need, for the 24 is what I'm talking about here, we need a longer term solution where if we get this young lady when she's 8, 12, 14, and we know we have to be careful, but we know that she's probably going to have a lifetime of institutionalization or some kind of serious assistance. It's not just for juveniles, it's for everybody. So let's have a solution that solves the problem that we're having with the hospitals for the more minor folks, and I don't mean to minimize that. That's certainly serious. But that's a different solution than the one for the people who are going to be with the Commonwealth and served by the Commonwealth, probably within a mental health institution. If we have the space for it, we need to get the space for it. If we don't, and we don't have it, by the way, for the rest of their lives. Very different. So I think this is a Band-Aid approach, and it's too expensive for a Band-Aid. We need a much broader approach for this. And you are the Commissioner of Juvenile Justice. Thank you for the professionalism you've brought. That has not been the case for the history of our interactions with you guys. So thank for what you're bringing. But this is not just a juvenile justice issue. We need far more people at the table and a much broader resolution for this issue, or we're not going to be helping the people that we want to help. Thank you, Mr. Chairman.
Representative Marzian.
Thank you, Mr. Chairman, and thank you for a presentation. It's kind of heartbreaking, really, and I guess I want to follow up on Representative Banta and maybe you, Representative Nemes, because I think 24 beds is way too small. And if we had a magic wand, you have 500 children in your facilities, Nancy. How big a facility should we build? And we need to start younger, I guess. So how many would we need? And also they need to be close. I mean, metropolitan Louisville, of course, Lexington, but these kids need to be close to family and friends. So if we have kids housed that are from Western Kentucky, Eastern Kentucky, they're never going to see mom or dad. So how many do we need?
You know, I think that on my side of the house, within juvenile justice, we're accepting of our role to manage the most difficult and the most at risk and the most dangerous. And that's what we're talking about. And to kind of go back to Representative Nemes to fill in the picture, one component that Kentucky has within its juvenile justice system is to manage detention. And what I call fresh off the farm. These juveniles come into detention fresh off the farm, and often we don't know or we have sporadic or sparse information as to what their medical needs are. And we're just trying to figure out what those needs are in detention and to stabilize them. So there is an intake process that we do very well, and we want to offer that continuum of care through the intake process and through trying to figure out what their needs are, what their mental health and medical needs are. And I know I'm making that very simple, and that's a simple explanation, but that's one of our primary concerns is when they come in fresh off the street and we don't have a lot of information and we're trying to figure out what's going on with these juveniles, what causes their behavior. And sometimes it takes time and it takes the professionals to do that. So that's on the front end. We are accepting of our role to manage the most difficult, and we want to accept and to manage the most difficult. There is a need for others to go to private providers, and we're conscientious that we want to continue working with the private providers to send the less dangerous, the lower risk juveniles for treatment. So I think what we're looking at with our site set on 24 is the most serious. And this wouldn't be housing 24 at all times. It would be housing those that needs the treatment, the stabilization on the front end for intake into detention when they're fresh off the farm. And then we can move them back to another facility once they're stabilized. But I think you had something.
And I think that's when we spoke with Senator Carroll, if we cannot accept that patient because they are more aggressive than the hospital can deal with, the idea is they need a place to go. But maybe once they could get stabilized, they could then come back to the hospital. So the idea wasn't, there's a continuum there. And we are going to continue to work to take the patients that we can. But when we can't, what happens to them?
And there are times that they get into a private hospital and they become violent, or their risk increases, it rises, and we have to accept them back. So right now, when we accept them back, we have to house them in a detention facility, not a hospital setting.
Commissioner, I have a couple questions. Have you been anywhere else, such as like Marion Adjustment Center, to look at the feasibility to remodel or retrofit a facility such as that, and kind of what Senator Wheeler and Representative Nemes mentioned about other locations rather than constructing a new location?
Yes, sir. I have toured Marion Adjustment Center a couple of different times for a couple of different reasons. Most recently was to examine that facility, the physical plant, the layout of that facility. And it's my assessment that that facility, it would just be extremely inefficient to try to operate. It's a huge facility. I think it can house 600 or 800 people. It's really got more space than what we need. It's not a treatment type of environment. It is an incarceration environment. There would need to be likely extensive renovation inside of the cells to make them suicide or self-harming resistant. And in physical plant design for housing high acuity youth, the facility was not at all designed to be that type of facility. It would require extensive renovation, and I think infrastructure upgrades as far as the technology, the cameras, wiring, fiber optics, all those things that goes into that design. And if there was a way, I would have tried to find a way because it's existing, it's in a good community. But it was my final analysis is that it's just not what we're looking for, not what we need.
And then my last question is, can you tell us where the proposed locations would be, perhaps for the high acuity facility and the two female facilities that you've testified about today?
Regarding the high acuity facility, obviously, as I've stated previously in this presentation, we would want to try to locate such a facility close to a major metropolitan area. The two most populated areas that would provide access to professionals, to services, medical services that we would need are the Jefferson County area and the Fayette County area. We have real estate in both of those locations that we could place such a facility on, so we wouldn't have to procure the real estate. We already have sufficient acreage in both locations. With the female facilities, again, we would want to try to locate those in the east and the west region. We think that probably in central Kentucky, somewhere in the vicinity of Fayette County, would be a good location for a female facility. And in western Kentucky, we have a law enforcement training center there and some property. I think it's in Hopkins County. I often get confused with Hopkinsville in Christian County and Hopkins County, but I think it's around the Madisonville area that we've taken a look at. Several locations there, but we have some property that we could probably co-locate a female facility in close proximity to a law enforcement training center there.
Thank you for presentation. Seeing no other questions, we do appreciate your time.
We appreciate having the opportunity, and thank you for your support.
One last question. I'm sorry, I had
Yes,
this
sir.
note, and thank you, Roberta, for reminding me. Can you go back over the costs associated with the three facilities? It'd be the two female facilities and then the high acuity facility.
I think in looking at what we requested in the past was in the neighborhood, off of memory, with the high acuity facility specifically was around $35 million at that time. A total package for all three facilities was in the neighborhood of around $90 to $95 million. And that's not counting operational budgets, but I'm sure that those amounts have increased because of things going on with the increases in pricing for labor, with raw materials, with construction. So we're looking probably in the neighborhood, and this is an estimate of around $95 million, but a more accurate assessment could be obtained from Finance and Administration.
Thank you for your presentation.
Thank you.
This time we'll transition to item number 5 on the agenda, Children's Advocacy Centers of Kentucky. This is our presentation, isn't it? Members, there's a presentation slide in your packets. At this time, if you could just introduce yourself for the record, and then you have the floor.
There we go. How's that? I'm Caroline Rochelle, and I am the CEO of the Children's Advocacy Centers of Kentucky, and it has been my great privilege to be in this role for over 12 years, and always a privilege to speak with each of you about the important work that we do on behalf of child victims of abuse. So we are very thankful for the ongoing financial commitment that you've made to a statewide model. We have one Children's Advocacy Center designated as the Regional Children's Advocacy Center in each of Kentucky's 15 area development districts. And each of these centers provides state-mandated services, and there are some additional service locations within those regions. So you can see that on the map on the screen. All right, so really quickly, what happens at a Children's Advocacy Center? So when a child makes an outcry of abuse, we hope a trusted adult makes a report either to 911, to law enforcement, or to the Child Protective Services hotline. And from there, either law enforcement or Child Protective Services will make a referral to a Children's Advocacy Center if it meets criteria for the types of cases that a Children's Advocacy Center would serve. And from there, what we hope happens quickly after that report is made is a forensic interview with one of our forensic interview specialists at a Children's Advocacy Center. And that interview will take place in a child-friendly facility where there's an observation room, and law enforcement, Child Protective Services, anybody else who needs to be included would be in that observation room to make sure that their questions and things are answered. So before Children's Advocacy Centers were around, we have some examples of cases where a child may have been interviewed up to 18 times in the course of a day, right? So they might have to talk to a teacher, a counselor, a principal, an advocate, law enforcement, a nurse, a doctor, more advocates, a prosecutor. And that was traumatizing for the child. That was bad for the investigation. And the model was founded on the idea that we can do something better. And so Children's Advocacy Centers were created again to have that independent and child-friendly environment where a good, strong interview takes place, hopefully quickly, for the cases that meet criteria for it. And then from there, Children's Advocacy Centers also provide medical exams. There are medical clinics at the centers, mental health services, advocacy services, in some cases, prevention education in the schools and that kind of thing. Okay, so the model was adopted somewhat early in Kentucky. It was back in the early 2000s that we rolled out a statewide model that we have, and we were early adopters. It is now in every state across the country. So this is a common practice of how things take place all over the country now. And just a couple quick slides about why this model is important and the impact that it has. You've probably seen some statistics on the impact that abuse has on our survivors. So we see that survivors have higher medical expenses. They are less likely to own a home or a car or have a bank account. And women who were child victims of abuse have 3 times greater long-term economic impact as opposed to men who are their counterparts. And so there's been some research, and part of the reason the model has become so popular across the state, and it's been something that many states now have adopted, is because there's been a lot of research around communities that do have Children's Advocacy Centers versus those that do not. And so what we can see is that for communities where there is a center, they're more likely to have a collaborative response or joint, we call that sometimes a joint investigation or multidisciplinary team response, where all the players involved in the investigation are working together. Much more likely to have that response, more likely to have access to medical care. Caregivers whose children are seen at a Children's Advocacy Center have higher rates of satisfaction. They feel like the response is better, and then prosecution rates are significantly higher. All right, so what are people in Kentucky saying about Children's Advocacy Centers? I have just a few quotes. We survey our youth and caregivers, and we have a response from youth saying, I felt calm and relaxed. A caregiver who said, I felt some relief. These are some common responses that we have, and we take that to heart. Most recently, Attorney General Russell Coleman made a comment about a case out of Perry County recently where he said he was deeply grateful for the amazing work of the Children's Advocacy Center professionals in securing a conviction there. So if you have not had the opportunity to visit a Children's Advocacy Center, we would welcome you at one of the centers. This is just a quick snapshot of what they look like. A lot of kids will say, this looks like grandma's house. That's kind of what we're going for, is a child-friendly, safe environment that is often different from the experience they might have if they had to go into a police department, for example, and tell their story. They would have a more child-friendly environment here. All right, so who do we serve? This is a snapshot of our clients. So primarily child sexual abuse cases, some physical abuse, some human trafficking, primarily female clients, 68%. And then the largest age bracket that we see is going to be that 6 to 12 age bracket. So this is a picture of what the growth looks like over time. So I mentioned earlier that we adopted a statewide model in the early 2000s. So back in 2003, Children's Advocacy Centers saw about 3,500 children. And today we're approaching nearly 8,000. So you can see that growth. And that is common, again, all across the country. It's not just something we're seeing here in Kentucky. Okay, and this is a breakdown of the services. So this is, you can see the volume of advocacy services, of case review services. That's going to be, again, those multidisciplinary teams working cases together. And then forensic interview, mental health, and medical exam services. All right. So I know some of you are familiar with this. A few years ago, we started asking a question about, are the cases that meet criteria for a Children's Advocacy Center and a multidisciplinary team response, are they actually getting those responses? Because the way that Children's Advocacy Centers were operating is that they were blind to the universe of cases out there. So let's say 100,000 reports of child abuse come in Kentucky, and the Children's Advocacy Center would only know about the case when it showed up at the door from law enforcement or child protective services, right? So we suspected that there were probably some cases that needed this type of response and weren't getting to us. And so we started asking questions about what can we do about that. And that's when we piloted a program in 3 different counties, one up in northern Kentucky, one in the western Kentucky, and one in eastern Kentucky, that just in those 3 counties, we started routing all reports of child abuse to the Children's Advocacy Center so that they could review the cases, identify which ones met criteria for services, and then see how many of them actually got there. And what we determined from that pilot program is that only about 50% of the cases that actually met criteria were getting there. And we also were able to determine that 15%, pretty consistently, of the total number of cases coming in met criteria for a Children's Advocacy Center multidisciplinary team response. So we worked closely with the Cabinet for Health and Family Services and created a system that now automates reports of abuse directly to Children's Advocacy Centers so that they can do an early expert review of those reports and then help engage with partners at law enforcement and child protective services to help support their work and their investigations earlier in the process. So we've been able to roll this. We've gone county by county, and we're in about 118 counties now. We've started doing this a couple years ago. And so we're seeing some very good outcomes. We reviewed 64,000 cases last year in 2025. And we now can see that an increase of 30% since 2021 when we started rolling this out are receiving that multidisciplinary team or joint investigation. And we believe this will have a tremendous impact as we continue to see this work being done in Kentucky. So this has been one of the most important projects I think that I've been a part of, and thankful for the work that everybody's done to help support this. All right. People always ask us, I know you do intervention work. Are you also in the business of doing some prevention work? Yes, we are. So there was some legislation passed in the last session that talked about prevention education in schools. And so we at the Children's Advocacy Centers of Kentucky take a look at that curriculum and keep an approved list of curriculum that meets the standard set forth by the National Children's Alliance on that education curriculum. And then we also have some staff members at Children's Advocacy Centers who are out in the schools doing prevention work. Also, sexual assault response training became mandatory during the last session for emergency department staff. So we've helped develop the curriculum for that and been engaged with that work. Other specialized training that we are doing, so our forensic interviewers that I mentioned earlier, they used to have to go travel to different parts of the country to get that training. We now have our own nationally approved curriculum in Kentucky, so people can get that here, which is great. Also for medical professionals, for prosecutors, social workers, law enforcement, we're doing a lot more training to help support our partners in this work. So just a little bit of what other work we're doing. And just as I close, I'd like to reiterate again how grateful we are for the continued investment in a statewide Children's Advocacy Center model. We could not do this work without you. Hopefully, I've given you a little glimpse of the impact that your investment has made in our work. And we look forward to we look forward to working with you some more during the upcoming budget session. Thank you.
We have any questions from members? Thank you for your presentation. I know I'm aware of these and the good work you all do, and I know it's tough work, and so thank you for helping those children.
Thank you. Thank you for your time.
This time we'll turn to our last item on the agenda, item number 6, opioid use disorder treatment in state and county correctional facilities. Members, as they're making their way to the table, there is a memo in your packets from Commissioner Cruz regarding this topic. Department of Corrections was invited, and they submitted this memorandum. Once you're situated, if you could just identify yourselves for the record, and you have the floor.
Hi, my name's Joyce Johnson. I'm Clinical Director of Outpatient Services for StepWorks Recovery Centers.
My name's Dr. Margaret McLadry. I'm faculty in the College of Public Health at University of Kentucky.
I'm Jailer Jody Perry, Jailer of LaRue County.
Well, Chairman and the committee, thank you so much for having us today. We really appreciate the opportunity to have this conversation with you. Like I said, my name is Joyce Johnson. I'm the Clinical Director of Outpatient Services for StepWorks. StepWorks has been in practice since 2004, so we've been providing addiction treatment in the state of Kentucky longer than just about anybody else has. I'm also the Education Committee Chair for KAIROS, the Kentucky Association of Independent Recovery Organizations. And I have a passion in providing and discovering and providing solutions to complex medical and social problems. I also have a passion in ensuring that people that typically don't receive equitable health care receive the same quality and quantity of health care as anybody else does. And so that has led to my work in the detention centers, ensuring that we're providing medications for opiate use disorder, specifically long-acting injectable buprenorphine. Buprenorphine is a gold standard treatment for opiate use disorder, and I have worked over the last year, about a year and a half, in creating effective and efficient solutions within our detention centers to provide this medication in conjunction with therapy, individual and group counseling, and some reentry case management services. So I brought Jailer Perry with me today. He's one of our jails, one of our first jails, and he's been a fantastic partner in this work.
So my story with this is, and how I got involved with StepWorks is when the DOJ sent out a letter to all the jails in Kentucky about the use of mats within the facilities, and we scrambled to get something in place to be able to satisfy those issues from DOJ, and so we started using like pill Suboxone, the film, and we've seen a very large uptick in contraband and the staff time and effort. And Joyce approached me with this avenue of this shot, and I love it. It has taken a burden off of my staff. There's a dramatic decrease in the amount of contraband that I find within the jail. Whenever we would do the film or the pills, we would have to observe them as an observation period that would tie up staff time. With the shot, I don't have that issue. And my working relationship with Joyce, it goes beyond just them coming in and giving these shots. I mean, there's a reentry portion to it. There's follow-up when they get out that I'm not a part of. and it's been a very big positive for us here at the jails.
And anecdotally, one of the things that we've found benefit in is creating relationships with people when they're incarcerated, so that when they leave incarceration, they have that established relationship with us and can continue receiving care. They receive then counseling within our office. They receive medications within our office. They also return to employment and are then taxpayers for the state of Kentucky, which has been huge. We've not seen anecdotally have not seen any recidivism in the people that we've been able to continue care with that have entered our program after being incarcerated.
So I'd like to clarify first that I'm speaking in my capacity as a private citizen, and the views expressed are not based on my own expertise and are not necessarily the views of the University of Kentucky. And as you see on the slide here, medication treatment for opioid use disorder is a legal and medical right for people who are incarcerated. Opioid use disorder is a disability according to the Americans with Disabilities Act, as Jailer Perry was alluding to, which prevents discriminatory treatment, including denial of clinically indicated health care. And the letter that Jailer Perry mentioned from the U.S. Attorney's Office for the Eastern Kentucky District in 2024 advised Kentucky Correctional Facility administrators that under the ADA, facilities cannot deny lawfully prescribed medication to individuals based on the type of medication described. And there have been and are continuing investigations into jail practices and settlements in place in Kentucky. However, there are legitimate logistical and financial challenges with providing comprehensive medication treatment in local Kentucky jails, which is why I do this work as an implementation scientist. I greatly admire the work of Jailer Perry and Joyce and other providers and jailers in Kentucky who are looking to solve this really challenging problem from a logistical perspective, from a financial perspective, and as well as addressing attitudes, education, and stigma around opioid use disorder and medication treatment. As you've heard from Jailer Perry, long-acting injectable buprenorphine can help reduce implementation barriers in jails. And if we could go on to the next slide, if you mind to scroll forward for me. Thank you. It can help reduce the different kinds of implementation barriers in correctional facilities, including custodial and medical time for administration, diversion concerns, the contraband piece that Jailer Perry brought up, violence and withdrawal management. Of course, buprenorphine also treats withdrawal in addition to long-term opioid use disorder, as well as replaces the daily substance use behavior that comes with daily dosing. And these benefits come while delivering the same critical outcomes for buprenorphine formulations provided during incarceration, including lower rates of mortality, illicit opioid use, HIV transmission, criminal behavior, recidivism in both the community and in carceral facilities. Also improved community-based treatment engagement, as Joyce discussed, especially when we're providing that kind of continuity of care from that care within the facility into the community. We also see with long-acting injectables and other buprenorphine formulations an 80% reduction in overdose mortality risk for the first month post-release. And that longer window between doses, when we're thinking about those other formulations where you have a 30-day and a month-long dosing window there, protects against the 120-time increased overdose risk immediately following release, while providing crucial time to secure community-based continuity of treatment and necessary basic needs. Medicaid reinstatement, of course, because the 1115 waiver does not apply to county jails, securing ID, housing, transportation, all of those different kinds of pieces. So as an expert in implementation science in local jails, I believe that long-acting injectable buprenorphine is an important tool for Kentucky jails and their medical providers to ensure the medical and legal rights of people in their care are upheld. Thank you so much for your time.
Senator Wheeler.
I kind of get where you're going at with this, and I'm not saying that maybe for short-term incarcerations this is perhaps reasonable to keep them on some type of taper if they're just going to be there for a week or two, to keep them on the regimen. But, what I have seen persistently is, at least my understanding of these types of medicaid-assisted treatments is that the goal is to get them off of it, to taper it down, over time. And yet what I've seen a lot of times is doctors don't taper it down. They keep on prescribing them because they come back every month to get dosed, and they stay on this for months, years, sometimes the rest of their lives. And, to say this stuff is not harmful is just not true, because you have, probably the number one legal drug that's, probably peddled on the street right now in eastern Kentucky is Suboxone. I mean, you got illegal fentanyl, you got, all the stuff that nobody's supposed to be using. But I mean, people are selling their medications now. I mean, it's a new market. I mean, you don't have your Oxycontins or oxycodones as much anymore, thank God. Now they're selling their Suboxone. And the concern I have with the implementation of this long term, and I don't care, maybe it is under the ADA. Hell no, there's a lot of stupid things under the ADA as far as I'm concerned. I mean, I wish they'd never pass. I mean, I'm not even going to get started here. But anyway, the bottom line is this is not helping people to get better. I mean, it's just causing the problem. I call them the walking dead back home. And you see them walking down the streets in the middle of the night, invariably in dark clothing. Just about every one of these people are on some type of either long-term medicated treatment. And, we got to figure out some way to get people off of all this stuff and just not keep them on it for the rest of their lives. And I just don't know that perpetuating this, especially maybe on the short term, to just keep their regimen going until we can get them off of it, I can understand. But to keep them in long term and put it on the taxpayers and pay them for it while they're in jail forever is just not right.
Well, I agree with you that the goal is always to discontinue these medications at some point in time. When we look at substance use disorders as a chronic medical condition, which we know that they are, there are a lot of chronic medical conditions that are treated lifelong. The importance of medication-assisted treatment, I think, is individualized care. And sometimes you see some bad actors absolutely coming into the state of Kentucky and providing these medications, not doing proper monitoring, not maybe coupling them with other types of treatment that a patient may need, not addressing mental health issues or other things in their life that perpetuate that substance use disorder. I disagree personally that the idea that every patient should not be on these medications long term. I think that we do have to individualize the way that we approach care for these people. I know that especially when we're talking about long-acting injectables, when they're receiving an injection and they're not getting a prescription of 30 or 60 pills a month, we see a decrease in that criminal behavior. We see a decrease in people selling their medications. They're not able to do those things. They also are required to be monitored. There's no street value for an injection because you can't do anything with it.
Not yet. They usually figure out a way.
Well, hopefully that's not the case. Hopefully, with the way that we administer these injections, they're not finding a way to have diversion with these. But I do agree that there are some downsides to medication-assisted treatment, primarily when we're not using it in a way that's responsible and in a way that is ensuring proper monitoring of people and giving them those life supports that they need to not become incarcerated again, give them the life supports they need to not be homeless, to not have some other things going on with them that perpetuate that addiction, even if the substance use has stopped.
And I would also corroborate what Joyce is saying, that these medications are being administered in a very secure facility of the correctional facility, and that's our main kind of concern here, and what we're speaking about primarily is the responsibility of correctional facilities where that monitoring is available.
And if I could just add, the difference between the other medications versus this shot is when I would give them the pill or the film, I would have to actually isolate them for a period of time and observe them as it works. But with the shot, they can just come out, they administer the shot, and I can put them right back in the population because they're not getting high off of it. And so that's a huge plus for me.
Another benefit we see to these long-acting injectables is because of the way that they work and the way that they last so long in the body, there is no withdrawal with these medications. So whereas with an oral Suboxone or a methadone, you may have a withdrawal syndrome that then puts someone at very high risk of relapse, very high risk of overdose fatalities. You don't have that, and that is a huge benefit of the long-acting injectables. Is if someone leaves detention, even if they haven't gotten their shot in a month, they have protection both from being able to have the euphoria that comes with using substances, but also with that withdrawal syndrome that puts people at such high risk of, the 120 times increased risk of overdose. You just don't have that with these long-acting injectables. And we even have people in the office that have been maintained on oral buprenorphine for long periods of time, maybe a year or two, that transition to a long-acting injectable in order to stop that medication and find that because they're not having that withdrawal syndrome, they just feel normal and they don't take another shot. They just feel normal.
Representative Mosier.
Thank you, Mr. Chairman, and thank you so much for your presentation and for your work. I wholeheartedly agree that this is optimal treatment for individuals who are suffering from this long-term chronic disease of addiction. We have individuals, we would love to be able to wean folks off of their medication, but it's as likely to occur in this population as it is with diabetics who are suffering from their long-term chronic disease. And we would love to have all diabetics manage their disease through diet and lifestyle changes and wean off of their insulin, but they're not likely to do that. And to further stigmatize this population because they, we finally have a treatment that works. And we've gone through several iterations of medication for addiction treatment. We have methadone, we have full agonists, we have partial agonists, we have methadone. We've got things, and finally we have the long-acting injectables that are completely addressing the diversion issue, and we have no issue, as Jailer, you discussed, with this drug when it's a long-acting injectable drug. I know that it does improve the odds of reentering society in a positive way. It keeps people from overdosing as they are exiting treatment or jail. All the things that we know that occur. So I just applaud the work that you're doing. We are looking to reduce diversion, and we're looking to reduce the drugs on the street. This is absolutely a solution to that. So I do have a question built in here. So the 1115 waiver that was just approved to cover substance use treatment in jail, is it the last 60 days?
I believe that's correct. It is the last 60 days. It only applies to state prisons. It does not apply to local county jails such as Jailer Perry's.
Right.
And to your point, buprenorphine as a partial agonist antagonist, the way that it works in the brain is it partially activates the brain receptor, but it doesn't fully activate it. So people don't experience a high. They may experience a sedative effect that they would get from any medication that has that type of activity on the brain, but they don't experience a high from it. And I do think that is important to note when we talk about its use as a gold standard treatment for substance use disorder. We really do eliminate a lot of those problematic effects of some of the medications that we have, and can use this in a way that perpetuates people's chances for success long-term.
Yeah, absolutely. And I would love for the 1115 waiver to eventually cover treatment and MAT in jails. Yes. So I guess the answer to the question that I had was, does this cover medication for addiction treatment? I guess the answer would only be in state prisons right now.
Only in state prisons right now, but the Department for Medicaid and Medicare Services is currently working. They did a comprehensive survey in late December 2024 to assess local jail facility capacity to be able to reinstate benefits and be able to think through what the Medicaid enrollment process could look like. So they're working in that direction. There's definitely high level of organizational readiness for that needs to be established and maintained, but that work is ongoing and part of our ongoing community of practice of jailers as well as medication providers and state officials who are looking to create these kinds of solutions. We're really following that data very carefully and trying to identify where those areas are that we can build that capacity needed for jails to be able to provide that medication, the Medicaid reinstatement and maintenance, because it's certainly, as we know from connectors and all the other kinds of capacity needed for that, it's a heavy lift, right, for a jail facility to be able to also administer Medicaid as a part of their overall benefits. So that is in process, and there is a survey that it could be released to you all if you are interested in seeing the results of that readiness assessment from DMS.
Yeah, that's perfect. And just one last thing quickly. The connection to the reentry services on the outside and to build that continuum of care into this population is critically important. So how are you addressing those connections to the outside world when individuals are released?
So it varies. We work in multiple different detention centers, so it varies based on the structure of the detention center, what other partners they have, and kind of what the structure that they want it to look like. My preferred method of reentry case management is having either a peer support specialist or someone that's trained as a social worker meet individually with people who are incarcerated and discuss their unique and specific needs. While someone may be able to leave detention and have a job and have a home to go back to, some may not. And so doing reentry case management on an individualized basis, working with people on their unique needs, I think is the most effective. The way that, and Jailer Perry can probably speak a little bit better to this than I can, but the way that we have seen the detention center environment in the state of Kentucky is that somebody that's in Breckinridge County may be returning to LaRue County, and somebody that's in LaRue County may actually be from Ashland, and so they're going back there. And so that makes it more challenging for people within the detention center to really work on finding resources that are suitable for them. And I think that's where partnerships like the one that we've created is really beneficial, because I have people that work across the state. They know resources in Ashland or in Harlan that I may not know. They know people in Paducah who are providing housing and different things. And that's the way that we've been able to make it work. It just takes time.
There's definitely been a shift in that attitude towards incarceration in the county jails. I mean, when I got into this business back in 1996, it was sit them on a shelf, they do their time, you let them out, and there you go. But there's been a shift into let's create an avenue for them to not come back, and then to actually rehabilitate and treat. And the establishment of these reentry services is the best thing that I've seen in a long time. And it's been an attitude change in the jails, and it's just not my jail. I have a lot of contemporaries who have done the same thing, and it's an integral piece to this whole puzzle.
Yeah. Thank you. That was my bill. I'm really proud of it. When I served as drug control policy director in Northern Kentucky, I had similar experiences with, why is this our problem? Why are we even, trying to focus on this population? But the more treatment and the more, especially medication for addiction treatment that we were able to stabilize those individuals on, we saw a dramatic decrease in the relapse and recidivism. So I want to keep working on this. Of course, we want to make sure that we're not diverting drugs on the street, but we are treating these individuals.
In the 3 years of my term, I've seen a 5% decrease in my recidivism rate, and I think that this is a part of that drop.
Representative Nemus.
Thank you, Mr. Chairman. I'll be really quick. I fully support what you're doing for the reasons that just mentioned today, especially by the jailer just now. We want to help these people, but more importantly, or as importantly, we want to help them not recidivate. I also want to note, because one of my colleagues may have said something differently, I fully support and am very proud that we passed the ADA. It is something that has been one of the greatest accomplishments of modern history, and so I want to put my full weight behind the ADA and all that it has done. I would note that if there's any doctors that are committing any misconduct and keeping people on too long, the Kentucky Board of Medical Licensure is now taking this very seriously. They used to not, but they do. They take it very seriously now, so turn the doctors in if they're misbehaving. But I do want to disagree with one thing. Opioid and substance use disorder, there should be a stigma. It is not good for the individual. It is a crime in most circumstances. And so there ought to be a stigma. I'm glad there is a stigma, and I'll continue to do what I can do to make sure there is a stigma, because with stigmas, it is a little bit of a distraction or an disincentive for people to do wrong. It's not good for people to have substance use disorder and to use things they ought not use. It's also a crime, so they should be stigmatized. We want to help them. We help them get back on their feet, but they ought to be stigmatized. I'm glad they are. And so, but I do have a question. When these folks are getting this service, which I'm fully supportive of, the shot, they leave jail, and I assume they continue the shot. Medicaid pays for it. How long they continue with your services? How long generally do they continue with those services that Medicaid is then paying for?
It is really individualized. We have some patients, I've been doing this for almost 10 years. We encourage, because my clinic is a rural health clinic, so we are primary care. I'm board certified in both primary care and addiction. And our focus is always holistic care. So people engage with us for long term. We always talk about we're a lifelong program. That doesn't mean that you're on these medications lifelong. We have people that have started with their care before I ever came to StepWorks and continue with us, even though they've been able to successfully transition off of these medications. Just as a general average, I would say probably what we typically see is around 5 years people are on these medications. They're able to successfully transition off, but maintain their engagement with primary care, maintain their engagement with mental health care. And when I first started providing care, we were focused on decreasing people overutilizing the emergency room for primary care needs and really engaging people with primary care. And we've been able to successfully do that. What we found in that experience was a lot of people that were overutilizing the emergency room had a substance use disorder, and that drove a lot of that inappropriate utilization of healthcare. So our focus as a rural health clinic and as kind of a addiction medical home is to decrease the cost of Medicaid. It is to get people back to work and onto commercial insurance. So I can't really give you an answer of how long these people stay with us, because my hope is forever.
Is any other questions? Oh, I'm sorry. Yes, Senator Thomas. He's hiding down there.
Thank you, Mr. Chairman. And I realize the hour is late, but Jailer Perry, your comments really caught my attention, so I've got to ask you this question.
Yes, sir.
You're the jailer in LaRue County, a relatively rural area.
Yes.
I mean, Hardin County is kind of mixed, rural and urban now. So it's maybe not completely rural, but relatively rural. You indicated that you've seen a shift in the last 5 years, toward more emphasis on preventing reentry, and you indicated that you've had a lot of success in your area of Hodgenville in doing that. Can you give me I'm just curious, can you give me one or two factors why that's taken place? Is it increased education? Is it more money being put into medical attention? I mean, what one or two reasons would you cite for seeing this success? I'm curious.
Well, number one, I mean, there's a lot of the DOC programs that we're giving with the inmates, like MRT, parenting. Also, with Joyce has a program where she has a fellow that comes into my jail for relapse. So a guy's been out for a while and he just makes a mistake and relapses and comes in. She has one that comes in and actually does sessions with him in my jail, and kind of helps get him back on track. And it's an attitude shift more of anything. Of the last sentence in my mission statement for my jail is, we're going to return better citizens to society. In the old model, it was incarcerate them, let them out, and it's here you go. But this reentry program of actually walking with them when they get out is huge. I mean, every 2 months I identify inmates who are within probably 60 days of getting out, and we have a whole conglomerate of resources that come in, everything from housing to mental health treatment to drug treatment. And Joyce's her team has participated in this as well, and they come in and they actually sit down with these inmates, and they're helping them get IDs, they're helping them get their birth certificates and social security cards, so when they get out, they're not just walking out on the street with nothing. They actually have an infrastructure and something to actually a step forward, and it's huge.
Well, thank you for that answer.
Yes, sir.
Co-Chair Elliott.
Thank you, Mr. Chairman, and Jailer, it's good to see you, and I always enjoy seeing local elected officials in Frankfurt. We always value your input. Within your Jailer Association, are you talking to other jailers about the successes that you have had with long-acting injectables? And I think you alluded to other counties who are following your lead. And if you could elaborate on that for me, I think you've found something here. So hopefully you're sharing that with your colleagues.
I just had a conversation last night with another jailer who is expecting a call from Joyce as soon as we leave out of here about coming to his jail and actually looking at doing this program. Just last night.
Thank you.
I have just a few questions. As it relates to the commissioner's memo that's in the members' packets. I was hoping there'd be more people here at this time, but at the top of the second page, it talks about DLC ensures the availability of all 3 FDA-approved medications for opioid use disorder. And so I guess the first question is the substance you're prescribing, you're talking about, this long-acting injectable, is it FDA approved?
Yes.
Okay. And just so the members are clear, they may want to go back and watch this video. Jailer, you've talked about issues with the films and pills being subject of contraband. Sometimes inmate might cheek their medication. That's a term that you might know as a state of art.
Yes, sir.
And that's when they keep their medication in their mouth, perhaps.
Yes, sir. They're magicians.
And so they could either accumulate more than the prescribed dose, they could trade that out. But is it my understanding you're saying that this injectable is administered?
It eliminates that, sir.
So no more diversion, no more cheeking?
When we first started this program with the MATs, before I got in contact with Joyce, I was finding several cell searches resulted in the finding of crushed up Suboxone. Since we've been doing the injectables, I have not found any Suboxone in my jail, and we routinely search.
And who administers the injectable?
Her team.
So it's not your guards, is that correct?
Correct.
And just so I'm clear, if this is prescribed, where would the individual go to once they're released from custody to get this administered?
We come into the detention center.
What about once they're released?
Once they're released, it depends on where they go. We have a mobile unit that's a part of this project that goes to 6 rural counties around Hardin County. We also have nurses that can travel to Lexington if they're in a sober living home that we've got a relationship with, or we can get them connected to a medical provider in their area that they're returning to, and I would imagine they would transport themselves to that person's office.
So the last series of questions, if someone gets the film prescribed, perhaps, what happens with that prescription? Does that individual take it home with them and they put it on their shelf and it's kind of like a vitamin or blood pressure medicine, cholesterol medicine, you have to take it each and every day?
That was not through Joyce's team. That was actually administered by my medical department, and that medication would stay at the jail. When they got out on that particular mat, they would have to go back to their original provider that they were with before incarceration. So, I mean, this allows a continuation of that treatment without it just going cold turkey.
Yeah. So my question, though, is if someone's prescribed the film versus the injectable, I want to talk about those two things. The film, they're required to take it daily?
Daily, yeah.
Yes, they take it daily, every day.
So upon release, if they're released, they have to take it for 30 days straight in order to achieve the same thing that one injection
Correct.
would last. Is that accurate?
That is accurate. The challenge with using the oral formulations in the detention center, as Jailer Perry mentioned, they don't leave the jail with those medications. And so based on provider schedules, based on their ability to transport themselves to an appointment, they may go several days without these medications after release, which contributes to that high overdose fatality rate because they're then going through withdrawal because they don't have these medications and are seeking out substances, returning to what's familiar when they leave incarceration, and that leads to a lot of really negative outcomes. The benefit with the long-acting injectable is even if they haven't had their shot, most of these medications are effective 45, 60, 100 days after administration, so they have some protection that allows them time to get engaged with a new provider or get back into their old provider.
And if you may not have any personal knowledge, but if you do have any personal knowledge, do you know whether or not the Department of Corrections utilizes the long-acting injectable or the film that we've spoken about?
I don't have any information about that.
Okay.
Sorry.
Thank you for your presentation. Any other questions? Thank you for your presentation. Thank you for your time. Members, seeing nothing else on the agenda, we are adjourned. Our next meeting is going to be Thursday, November 6th at 11 a.m. And Co-Chair Elliott's going to take control of that one.